appeal in the matter of JTI Acquisitions Company Limited and the Commissioners for His Majesty's Revenue and Customs Parthad.
Yes, Miss Wilson.
Thank you. Could I just check that the court received the transcript?
The transcript's arrived, yes?
Yes, that. I do have hard copies if you want them. I don't
Well,
intend
I've only
to
got
take
it electronically
you to
and I haven't
but
brought it with me into court, so I don't know if you're going to refer to it.
I'm not, but I've got hard copies if you want them. But
Speaking selfishly, if you have hard copies available, then I wouldn't mind taking one.
Yes, why not?
free?
We'll all have
yes,
them
then I can.
if they're here.
So at the close yesterday, I took the court to the evidence showing that the appellant's directors were well informed about the
Yes,
Deloitte
indeed.
scheme and the role assigned and were willing participators.
Yeah. You ended by saying, according to my notes anyway, I haven't been back through the transcript, that without the Deloitte scheme, the appellant would not exist.
Yes.
I thought it was a principle of statutory construction that where you've got a pre-planned scheme, you must look at the scheme as a whole. But that doesn't seem to be the way you're running the case. Am I wrong about that?
What I would say on that is that this, underpinning the approach to section 441 and 442 is the Ramsey principles of construction. So we give it a purposive approach and we view the facts realistically. But the case is fundamentally about what whether on the facts found, the purposes found by the first tier meet the statutory test in 442, little 3 and 4, and then whether the attribution was a rational one that was open to struggle to make. So we're not looking so much as at it being a preordained scheme and whether for the purposes of applying the legislation one might be disregarding certain steps or not. So when I made the point that there would be no appellant, in other words, no UK company absent the Deloitte scheme, that's simply a conclusion on the facts of the case because of the finding that the Deloitte scheme was bolted on to secure the tax advantage. So no tax advantage, no UK co to fulfil the role in the scheme. But to finish just in relation to the directors and their purposes, as regards the board meeting itself on the 20th of June, the first tier found that there was no real function to that decision commercially in the context of this Deloitte scheme, beyond the appellant fulfilling its role in the scheme, which of course required the correct company law conditions and T and C to be ticked. We wanted they would have wanted an effective decision to make sure that the contract was legally binding in relation to the loan and the assignment and so on. But beyond the board agreeing to fulfil their role in the scheme, that decision on the 20th of June had no real content relevant to asking what were the purposes of the company in entering into the loan relationship. And that was really because, on all the facts, the appellant's participation in the Deloitte scheme was a done deal, and that was the phrase used by the Upper Tribunal when they reviewed this aspect of the first tier's decision. And that's the finding by the first tier at paragraph 153, which my learned friend took you to. So that's paragraph 153 of the first tier decision. What is slightly upset the appellant is that use of the word no genuine decision making. And this was the subject of challenge below in the Upper Tribunal, very much on the sort of Edwards and Bairstow basis. And that was the basis on which the Upper Tribunal reviewed this. And the Upper Tribunal's reading of paragraph 153 in context and in light of what the parties had been submitting on this issue was that the word genuine there was rather inapt, that what the tribunal was really getting at was no functional or real commercial decision. The tribunal was not finding that there was no valid decision as a matter of company law, for example, but rather that it was decision that had no function in the context of the scheme, which meant, of course, that you would be looking to events before. You could look at facts that occurred before the board meeting to ascertain the subjective purposes of the company. And of course, we know that Mr. Olsen had done all the thinking. So we're not shut out from looking at that.
Well, the part of the finding of 153 is that the decision makers were at JTI level.
Yes, and in relation to the scheme, and in that sense that it was a done deal, and what the appellant was being asked to do on the 20th of June was confirm as a matter of sort of bare company law, if you like, that this was an appropriate thing for the company to do, and that resolve appropriately to enter into the contracts. But that realistically, the chances of Mr. Olsen having done all the thinking with Mr. O'Brien at the Joy Global level, and all the money having been spent on the fees and so on, the chances of realistically Mr. Olsen suddenly saying, oh, well, actually, this isn't a very good idea after all, on the 20th of June in that 45-minute meeting or whatever, was negligible. It's not to say they didn't make an effective decision as a matter of company law, or that wasn't a decision, but for the purposes of identifying the subjective purpose of the company for being part of the loan relationship, it was not really a particularly informative decision. And in what I would like to do is invite this court just to adopt what the Upper Tribunal say about this, which is at paragraph 139 to 140. And
Sorry, say a paragraph again?
139 to 140. And you were taken to that yesterday by my and it follows not only from the submissions being made to the first tier by the parties, but from the findings made by the first tier at paragraph 152. And if I run briefly through those to show how it leads to the finding at 153 as understood by the Upper Tribunal, that will also save me time on the grant.
So you're going to do the 12 subparagraphs in 152?
Yes, that's right, thank you. So these are the findings that lead to the conclusion in 153. And they go to 2 points. The first arises out of subparagraph 1 and 2, which is the decision that the board is making on the 20th of June really was a different decision to the one made by Joy Global leading up to the 13th of May SBA, the agreement with Rowan to buy LTT. And the tribunal say that purchase with Rowan was locked into place before Deloitte turned up with its scheme. And so the decision whether to buy LTT at all, for all the commercial reasons that were factored into the decision and resulting in the contract of 13th of May, they were all made before the Deloitte scheme was put to the group. And of course, before the company was even, the appellant came into existence. And all of that reasoning was acted on. So we end up with the 13th of May contract. So then the following findings, which are from 3 through to 9, actually, they go to the fact, explaining the sense in which it was a done deal that this scheme was going to go ahead. So just to pick up an example, at little 3, Mr. O'Brien's distilled the Deloitte scheme into the 9-step skinny. He's worked out all the steps, he's mapped out in detail what needs to happen. At little 4, it's then bolted onto. So there we get this finding that the Deloitte scheme is separate in nature to the Rowan, the Joy Global Rowan acquisition. And then, for example, we've got, if we drop down to little 8, the first tier, they read all the emails and the correspondence internally within the group and with Deloitte, and they're struck by the way in which Mr. O'Brien describes the scheme to others. So Mr. O'Brien says the scheme was presented to Joy UK, so that's the UK operating group, as an acquisition that will provide Joy UK with some fairly substantial prospective tax saving. Not just that it's tax driven, but that he's presenting it as something that is going to happen. And you can see that arises elsewhere from the decision, that she sees that this is a done deal. And then 9 is very interesting. So despite the grave reservations of Joy UK, as summarised by Vicky Willis, she had her list of concerns. There was no option for Joy UK but to go along with the decision to implement the scheme. And that's interesting because Joy UK are real life operating companies in the UK with a real life relationship with the Inland Revenue with a view. So if anyone could say no to this scheme, it would have been Joy UK, and yet they're overridden. So if Joy UK can't influence the decision, what hope for our empty UK appellant who's playing its part in the Deloitte scheme? And then over the page 10, 11 and 12, these really go to what the tribunal viewed as window dressing, because Mr. Elton was actually quite upfront about the fact that he'd done all the thinking and he didn't need the tax matrix to know what was in it on the 20th of June. And in this case, the first tier, having heard all the evidence, took the view that there was a sort of artificiality to it. These board packs and so on were being put together for presentational reasons. And that was open to her to find that. So you've got all of those factors then lead to this conclusion in 153. And as the Upper Tribunal said, I think the word genuine is maybe wasn't the most perfect word to have chosen there. But for those reasons, and the reason given by the Upper Tribunal, I think there's no error of law here. There's no suggestion here that the tribunal applied the wrong legal test. She didn't suddenly say, well, let's go and ask someone else what they thought or what they intended. Yeah. She was continuing with the application of the correct legal test, which is she had in mind that the appellant company's purpose was the relevant purpose. So I now have just 2 more propositions relating to the facts found, and then I can just draw ground 1 to a close. So the first of those 2 is this, and it's that the first tier rejected Mr. Olson's evidence that the decision to use a non-US entity to acquire LTT preceded the decision to place the debt in the UK. And so the gist of the appellant's case here was that there were good commercial reasons to have a non-US entity acquire LTT, despite it being a group headed up in Texas, being bought by a US company. And that thinking preceded, in effect, the realisation that there could be UK tax advantages if it was one of the non-US company happened to be in the UK. Now that was all rejected by the first tier, and I think where one finds it is that it's in the rejection of all of the commercial reasons put forward for having a UK company. Not one of them were found to have been made good on the facts. So in the absence of any commercial reason for having the UK company, how could they have made, what decision were they making to have this non-US company performing these useful commercial purposes when not one of the so-called commercial purposes was made good on the day? Mr. Olsen just couldn't back up the proposition. And it comes out also from paragraph 157, which the tribunal's been taken, I'm sorry, the court has been taken to on a number of occasions.
Now, picking up Ms. Shaw's questions, as you recognise, you are concerned with the purposes of the appellant company, whichever group of individuals you're looking at. At the stage at which they make their decision to borrow this money, albeit that perhaps there was no reason other than tax for the company to exist at all, why can't you say, well, they had a commercial purpose in borrowing the money to effect the acquisition that they were making?
Well, the only commercial purpose would be, if this is a commercial purpose, acquiring LTT by the assignment from Joy Global. That's it. Not one other commercial benefit was made good on the evidence. So then, of course, you have to ask, well, what were the directors really thinking? Why were they agreeing to take these steps, to borrow so much money to acquire this asset? Why? And they knew why. Why it was important that they did that was because of the group benefit, the group cash tax saving. And they knew why they were being asked to do that, and it was the group cash tax saving. And I think the Upper Tribunal really, I think, probably nailed this whole case, if you like, with their paragraph 99, where they said, any disquiet about this case is put to one side if one remembers that the purpose of the Deloitte scheme was to park LTT in the UK solely to secure the UK tax benefit. And that, of course, was something that was known by Mr. Olsen and the other two directors of the board. So they knew why they were being asked to do this. And it was perfectly legitimate for them to act for the benefit of the wider group. And that's what they were doing. And my learned friend sort of, threatened that the world would come to an end if the Upper Tribunal was really right and the First Tier was really right. But not so. It's not the end of all normal commercial arrangements or transactions. This is a case where there was literally nothing. On the day, Mr. Olsen could not explain or justify any one of his so-called commercial reasons for having LTT held by a UK company. And of course, an individual company who's a trading company and buys an asset, which is a UK company, might be, you can think of lots and lots of examples where there'll be no difficulty. They want to hold their new asset in a new UK company, held beneath the head of the group, because they want to divide up their different trades, or because this company has particular difficulties, or whatever. There will be some reason why you're doing this. This case, not one reason could really be put forward. So literally, they're the bear holder of an asset. That's it.
Yeah.
So then the final proposition in relation to the facts is that the First Tier found as a fact that the main purpose, in fact the sole purpose, for becoming party to the loan relationship was to secure the tax advantage. And in fact, for for all the points I've just made in my submission, I would say that that was clearly a finding that was open to it. And the particular paragraphs would be 172 to 174, and they contain no error of law. My learned friend quibbles about using the fact that the paragraph 173, the first tier considers the $6.87 million figure. So, and then the finding that, well, 68 million in absolute terms is clearly important and motivating and large. And she says, well, actually, you should look with hindsight to the benefit of Vicky Willis's, I think it was, calculations done in November 2012 after they made the decision to enter into the scheme to assess their purposes when going into the scheme. Well, that makes no sense because it's a purpose test and it's forward-looking. And that comes out clearly from Quick Fit, at paragraph 95 of the Court of Appeal judgment. And in a sense, it goes without saying, it's a purpose test is a forward-looking test. And Mr. Olsen would have known that the actual quantum of the tax saving would be a function of the corporation tax rate in the year, which often fluctuates or changes from year to year, but also the interest rate agreed with the revenue for all the other provisions like transfer pricing on the loan between JTI and the company. And they project the benefit on the basis of 5%, I think, LIBOR plus 5%. In fact, it turns out that they agree a lower rate, so the tax benefit's reduced. But what they want on day one is to secure the most benefit they can within lawfully within the legislation and the transfer pricing rules. For those two reasons, it's a forward-looking test, and Mr. Olsen would know that there could be a fluctuation in quantum. You can't just sort of look backwards and say, oh, well, although it was main on day one, it's not main at all. That makes no sense. And of course, this is evaluative, and the tribunal was entitled in my submission to focus on that 6.8 figure. At 174, she moves on to a cost-benefit analysis. So again, you see the tribunal conducting a proper inquiry, looking at what was important to the company. And she says it's large in absolute terms. And I should just say, the appellant didn't produce any evidence that 68 million was a drop in the ocean for its UK group, or even actually that 38 million was a drop in the ocean for the UK group. The UK tax saving for the UK group. So these are large figures. And then at 174, in my submission, the first tier was entitled to reject the appellant's submission that the relevant comparator, so you take your 68 million, and then you compare it to the 1.1 billion purchase price of LTT. Now, there will be some cases where that might be a relevant comparator, but on the facts found in this case, it's not, and at least it was open to the first tier to find that that was not a relevant comparator, because of all her findings she's made, that this was a tax scheme bolted onto, and with a separate life, if you like, to the LTT acquisition from Rowan. And all the facts that I have highlighted all go to explaining why it was open to the FTT to make that, to choose that as the comparator. No Deloitte scheme, no debits, no UK co. So she's perfectly entitled to say, well, it was obviously important. It was so important they created a company just to get the tax advantage. How could that not be our main, if not the sole purpose, or capable of being? So I say then, they are the facts found looking at the tribunal decision. And what I say is that given the facts found and the approach taken by the tribunal, functionally, whatever she might have said, and I'll just briefly look at the passages that my learned friend said showed an error of law. functionally, the tribunal applied the correct test as we now know it to be and helped most usefully set out by this court in BlackRock and QuickFit. I mean, standing back, that First Tier finds at paragraph 167, the Deloitte scheme was bolted onto the LTT acquisition for no other reason than to obtain a tax advantage. The Upper Tribunal at 99 put it as LTT being parked in the UK. And they're the findings of fact, and they result from functionally an application of the correct legal test. So then if I just look at the test actually set out on the face of the decision, again, on this, I adopt what the Upper Tribunal say. There was no error of law if you read it fairly. And so the first question, of course, we've rather haven't focused on this, is whether there's a tax advantage. And within 1139, the First Tier correctly asks itself that question at 128. It finds that group relief is a tax advantage, no question of that being any error of law. So the rather more contentious paragraphs relate to the purpose test, and that's paragraph 142 and 143. And my learned friend accepted that the First Tier on the face of the decision set out the correct test at 142 and at 143. So there's no doubt here in the tribunal's mind that you're asking what is the purpose of the appellant company in being party to their relationship. And then at 145, and to be fair, if I can say this to the First Tier, this decision was written before really even the Upper Tribunal decision in BlackRock. So this is the tribunal feeling its way to what is the correct approach, relying on Brebner and the transaction securities cases. At 146, so at 145, the tribunal sets out Brebner, and I think it's common ground that Brebner is a relevant guidance in the context of these cases. Then at 146, I take from Lord Pearce's observation two guiding principles for my findings of fact. First, while the nexus of the unallowable purpose test is anchored to the act of the appellant in issuing the loan notes, so that's absolutely correct, and it's a reflection of the tribunal's understanding that you ask, what did the appellant company intend, or what was its purpose? And she goes on, thereby entering into the loan relationship. But she says it would be unrealistic. Now, the next passage is, everyone accepts wrong. So, but if one were just to put a line through, and not in accordance with subsection 4421B, what she's saying is absolutely correct. She's just added in an extra wrong justification.
So if the sentence had read, it would be unrealistic to suppose that the object of the directing minds of the appellant has to be ascertained in isolation at each step.
Absolutely.
You say that's
correct. Correct, in light of BlackRock especially. And then I would delete subsection 4421B, clearly anticipates, because she's back to the second justification. Yeah. But Brebner is enough. And everybody is common ground that Brebner is relevant. And what she says there is absolutely correct in light of BlackRock. And equally, so I think one would delete right up to, from subsection 4421B, one would delete the end of.
Well, I mean, that approach to statutory construction is, as I said to you earlier on this morning, that's Hornbook law these days. It's all in Rossendale and Hurstwood, and it applies to every statute. It's not just peculiar to tax.
Absolutely, and actually, I would say you don't even need a purposive construction to approach section 442 in this way, because actually there's nothing in the words that limits the inquiry. But the Rossendale just puts it, beyond doubt, which is, why would you read it in some narrow, strange way to create a test that doesn't have any bite? And so 146, no error of law. No material error of law.
And that's what the Upper Tribunal said. They said, yes, you did make a mistake, but it wasn't material.
And then 147, this is slightly more complicated because she's moved into looking at the actual facts of the case. She says, secondly, the object is a subjective matter. So now she's quoting from Brebner, to be derived from the intention and acts of the various members of the group. Now, in Brebner, on which she received submissions, that was because it was a reorganisation, so that some of the decision-making was made by shareholders rather than the directors. So the directors aren't always the relevant decision-makers. But that's about Brebner. Then she says, in the instant case, the directing minds weren't confined to the three directors for the appellant, who were supposedly the decision-makers approving the resolution. And then she says, and this sentence, is, to be fair, is slightly hard to, not immediately transparent. She says, as a corollary of the first guiding principle, the object of the directing minds necessarily included the key personnel who were directing the affairs of JDI and JTI in relation to the interconnected transactions in the 9-step skinny, which had come to assume an organisational status as being an integral group plan encompassing step 6. So actually here she's actually moved on to making a note about the facts of the case, which is this group, this Deloitte step plan was had this status of a group endeavour, if you like. So it would be artificial just to look at, especially remembering what arguments were being made by the appellant, it would be artificial just to look at what was in the minds of the board on the 20th of June, having received, let's say, the doc numeno, which says they're not allowed to look to the wider group benefit. That would just be wholly artificial. What she said is that the plan has got an organisational status as an integral group plan. And so you need to look in finding, I mean, it's quite clear from 142 and 143 that she knows that we're looking for the purpose of the appellant. What she's saying is to find the purpose of the appellant, you may, in a case like this, need to look at the wider purposes because they will inform the company's purpose. That's how the Upper Tribunal construed this. But
does that quite fit? I mean, if you go on to 148, what she seems to be saying is not just something about the purpose, but something about whose purposes matter. And so the directing minds include the directing minds of JGI.
But in the end, when she comes to apply and find facts, she is finding the purpose of the appellant company. And what we've got, the reference to Garforth here is, the point being made in Garforth is that it was a wholly and exclusively case. So you're very much looking at the subjective purpose of the taxpayer company. So she's still in this arena where the test is to look at the statutory purpose of the taxpayer company. So she still has that in mind. But in Garforth, you have, maybe rather like Mr. Olsen, you've got an individual who's done all the thinking and is making all the decisions, who wears lots of different hats. He's a director of hundreds of companies. And you've got this group plan. He begins thinking about the scheme as a director and CFO, maybe, sorry, I can't remember now, of Joy Global, because the appellant doesn't even exist. And then he's made the director of the appellant because he knows everything about the scheme and he knows what the appellant has to do. And the Garforth point is really, if Mr. Olsen is going to stand in the witness box and say, oh no, when I made the decisions on behalf of the appellant company, I was able to completely disregard any group benefit that had actually influenced me in deciding whether I was going to ask this company to make that decision, then that's just unreal. And it's not for the witness just to state it. It has to be made good on the wider evidence. It has to be corroborated. But behind all of that, and this is the point that the Upper Tribunal make, is it's all about finding the subjective purpose of the taxpayer company. That's the context. So it's recognising that Mr. Olsen moves from being deciding that this scheme is going to go ahead in one capacity, but then he's picked to be the director of the appellant because of who he is in the other capacity.
And can I just take you back to that last sentence, paragraph 147? To make it read correctly, do we omit the words "the object of"?
I think that would make yes, I mean it. When I come back to this, I must admit sometimes it's hard to know what it's saying. Yes, that would be one way, and but the directing minds would be looking to factually, it would actually be Mr. Olsen. I mean, it's a rather difficult sentence because one might just say it doesn't make any sense.
The thing is that I suspect it does make sense if you take out the words "the object of." So then it would be, as a corollary of the first guiding principle, the directing minds necessarily included the key personnel.
Yes. Yes, but and then when she came to find the facts, I showed the court evidence that there's no doubt that it was as director that the formal decision was made, and then Mr. Olsen was, of course, acting in two capacities. So his decision, if you like, his decision in every capacity tells us the purpose of the company in this particular case, because he's one and the same man. But of course, standing back, even if there was something that came out rather wrongly, if you like, there was some error of law in how she expressed it there. If we actually look at all the facts found, we know from Blackrock that you can't just look at what the directors resolved on the day. You can look at the wider circumstances and contemporaneous documents to infer what the company's purpose was. And so that wouldn't be an error of law which would justify setting aside the whole of the First Tier decision and then the Upper Tribunal decision. But actually, I think there's an easier route to that, which is there isn't an area of law, it's just fact specific to this particular case. And just for your note, the Upper Tribunal addresses this at paragraph 76. That's where they deal with paragraph 147 of the First Tier decision, and then also 78 to 79. And that's where they deal with paragraph 148. And that is our case.
76.
It's 76 deals with paragraph 147 of the First Tier decision.
That's when they say she made a mistake, but it wasn't material.
And then 78 to 79 deal with
Yes, I think what the Upper Tribunal was saying is more or less what my Lord Justice Newey put to you.
yeah, so you can look at outside, and here she did to inform, but the key point being to inform the purpose of the appellant company. Thank you.
Yeah.
So the upshot of that is, I say there's no error of law, no material error of law in the Upper Tribunal's decision, which I suppose is strictly what's being appealed against here. And the Upper Tribunal were absolutely right to find that there was no error of law in the First Tier's decision, no material error of law. And that means ground 2 doesn't arise in my submission. And what's clear is that the First Tier and the Upper Tribunal, neither of them are simply asked, why did the group choose to locate the appellant in the UK? And then answer that question and say, well, then there you go, the unallowable purpose rule applies. That's not what happened. And nor do they confuse knowledge and purpose or make any of the other errors alleged. But I should deal briefly with what my learned friend said would be well, my learned friend invited this court to, first of all, set aside the decisions below, and then to remake the decision.
Yes.
And there are a number of problems in my submission with what my learned friend was inviting you, this court, to do. The first is that she was not inviting you to remake the decision applying the legal test as set out in Blackrock and Quickfit. It's the appellant's own test, it seems to me, in my submission. And the first important point is that it does involve attributing Joy Global's purpose to the appellant. And that's contrary to the findings of fact. So it must be some principle of law that's being relied on there. But there's no such principle of law. And we're only in ground 2 if there's been an error of law in ground 1, which involves, on my learned friend's case as set out in her grounds of appeal, asking the wrong question, which involves the wrong question being attributing Joy Global's or the wider group purpose to the appellant company. But then that's exactly what she's inviting this court to do. So that's first fundamental problem with her case on ground 2. Further, alternatively, it's setting up a test, a purpose test, where, to put it sort of bluntly, the group purpose can inform whether a company's got a commercial purpose. In other words, if it helps the taxpayer, you're not allowed to look at the group purpose if it results in an unallowable purpose, and that's obviously a nonsense. I wanted to run briefly through her 9 factors, or the 9 factors that were put forward, on which my learned friend relied. The first is that one can attribute the purpose of Joy Global to the appellant. And I say, well, if we're in ground 2, we have to delete that factor because it's illegitimate. There's no finding of fact that they had the same purpose, so you can't make that attribution. So that fact can't be relied on. So then what we're left with is a series of really mostly a mix of cherry picking combined with, again, looking to the group purpose to help find a commercial purpose, which is illegitimate. So factor 2 was that the Deloitte plan is just how LTT is to be acquired. But of course, that's not the facts found by the first tier. The first tier found that they were separate, that the Deloitte scheme was bolted onto the LTT acquisition. So this relies on facts which weren't found. It also strays into the territory of attributing a group purpose to, or rather, asking the wrong company's purpose. Because if you describe this as that the Deloitte plan as just being how LTT acquires, there is a risk that what you're really doing is asking, what did Joy Global want? And that's, of course, not the test. Factor 3 is similar. The Deloitte plan.
On your point about the scheme being bolted on, I mean, if we remember Brebner,
Yes.
Where Lord Pearce and Lord John, was it, both said it would have been open to the commissioners to find that there were two elements to this and deal with them separately.
But I say the first tier in this case.
And you say that's really what that's what the FTT really did.
Yes, absolutely. And my learned friend said she wasn't seeking to go behind the findings of fact.
Yeah.
factor 3 amounted to the Deloitte plan was just a tax efficient means to achieve the purchase. Well, that has the same problem, which is the facts don't make that good. I mean, it's sort of true in a very trivial sense, but it's not. It's not the facts found because, for the same reason, because the scheme was bolted on, because the group, the scheme was designed to secure the tax advantage, and I think that's conceded. And then factor 4, Mr. Olson's evidence in.
But the two shade into each other. I mean, it's
Yes.
tax efficient to secure a tax advantage.
Yes, it's tax efficient to have an unallowable purpose, apart from the fact that it'll be denied. So, but yes, and it's rather a conclusion. It's more a conclusion after the event. So the point really for today is that my learned friend needs the facts to back it up, and they have to be much more granular, and they're not there on the face of the decision. Factor 4, the point's made that Mr. Olson's evidence in paragraphs 95 to 103 is consistent with a tax advantage being understood and intended, but not being a purpose. Well, but 2 points to make on that is that the paragraph 6 of the tribunal decision, where the First Tier expressed reservations about Mr. Olson's evidence. So one really does need to look at what the tribunal concluded from all of the evidence, including Mr. Olson's cross-examination, to find out what its import was. And you can't just go to a little bit of his cross-examination and say, oh, well, look, that's consistent with there being no unallowable purpose. Because we know that the tribunal had reservations about what he was saying, and they were viewing the case as a whole. But equally, the fact it's consistent with a tax advantage being understood and intended doesn't impugn the First Tier's finding that actually it was a purpose. So the fact it could have been decided either way doesn't mean the First Tier was wrong, and my learned friend can't go behind the facts. Factor 5, I've made this point already, but in my submission, the appellant misreads paragraph 157 of the First Tier's decision. It's a rejection of the proposition from Mr. Olson that the decision to have a non-US company preceded the thinking about the tax scheme. It's not a finding of fact in the appellant's favour. It's a rejection. And then factor 6 is the loan was at arm's length. Well, that's neutral. That's Quicklet and Blackwood make that clear. And factor 7, the use of the borrowing or the borrowing was deployed to buy LTT. Well, yes, but that doesn't take us very far given the wider context in which that occurred. We know there was no commercial purpose for having the appellant spend that money to buy LTT other than to secure the tax advantage. And then factor 8 is that it's only worth 3.8 million at the end of the day. But this is a purpose test, so we look at what was hoped for. And my submission is that's exactly the same as the submission I made. So there I have 8 factors, and I said she had 9. So maybe I better just check. There was a 9th. It would be about page 95 of the text. There were 8. There were 8.
Yes.
Thank you. Good. So there aren't the findings of fact don't get my learned friend home, even if her test was the right test. She also, my learned friend also made some submissions on paragraph 152, 1 to 12, and actually, I mean, I've set that up if you like, because I've already made those submissions. And what the submission that was made was that those paragraphs, and in particular subparagraph 1 and 2, showed that the appellant shared Joy Global's purpose in acquiring LTT. And I say, well, how do you get that from sub 1 and 2? What you've got is a commercial decision made and acted on before the Deloitte scheme and the appellant come into being. So that's not enough to assist Marlene Friend's case. And she also seeks to explain away the negative, or really probably 3 to 12 actually, which are the points against the finding that she would be asking this court to make. But what she's really doing is putting a different spin on it. But the tribunal found the facts. And I think the right spin, or the correct way of reading 152 is the submission that I made earlier. And also it has to be read in the context of the decision as a whole. And you can't just look at 152 and say, well, there you go. This is enough for this court to remake the decision and find it favour of the taxpayer. And so she concludes, Marlene Friend concluded by saying that the Deloitte plan was just one aspect of the LTT acquisition. And the single most important objective was to acquire LTT. Well, that might be true of Joy Global in making its decision whether to buy LTT at all. But it's illegitimate to elide the purposes of Joy Global in making that decision with the purposes of the appellant in playing its part in the Deloitte scheme. As Lady Justice Falk said in Blackrock, I think it was, there may be cases where they have the same purpose, but it's a question of evidence. I might be slightly misremembering or misquoting, but in any event, it is a question of evidence as to whether that's the case. And it's not the case here on the findings of the first tier. So my submission on ground 2 is it doesn't arise. But if it did arise, I would invite this court not to adopt the test proposed by Marlene Friend. And it's rather difficult to make any submissions on what I would be inviting the court to do, given that I say there's absolutely no error of law whatsoever. What the court would be doing is applying Blackrock and Quickfit legal tests to the facts as found on the face, and I say there's only one answer. So that then leaves ground 3, which is the attribution. And I think I can deal with this shortly. The law is now clearly set out in my submission by this court in Blackrock at para 179 and 180, and also in Quickfit at paragraph 99. And the essential point is it's an evaluative exercise and it's an objective exercise. So one can look at all the facts without any concern, which requires apportionment by reference to the relevant purposes. And the exercise is a fact-specific one. So here, the first tier make its attribution, and it's at the end of the decision, it's paragraph 166, and then also 177 to 180. And it makes its findings in the alternative. So its primary finding was that there was a sole purpose for being a party to this relationship. So actually, it's quite easy, you know, that it's rational to, just unreasonable to attribute the whole of the debits to the sole purpose of securing the tax advantage. But then she says, well, but even if acquiring LTT just to hold it is a commercial purpose. So now there are 2 purposes in play, the unallowable purpose and this commercial purpose. She says still that all the debits should be attributed to the unallowable purpose. And she does that in taking account of, or applying, I would say, a fact-sensitive and evaluative test. And for all really the reasons why she found that it was our main purpose, it's a tax scheme bolted on, but for the tax scheme there'd be no appellant, no loan relationship. She was entitled, it was open to her to attribute all the debits to the unallowable purpose. That's not to say that there might not have been other attributions that could have been made, but that doesn't matter. The question is whether the attribution made by the first tier meets the statutory words, which is it a just and reasonable attribution, and meets quick fit, paragraph 99, done by reference to the purposes. And that's precisely what the first tier did. And the Upper Tribunal then consider that and find no error of law.
To what extent is the FTT arriving at an evaluative decision on the facts? I ask that question because paragraphs 178 and 179 seem to, well, it might be suggested at any rate that the FTT is directing itself, it is required by FIDEX to make the attribution that it did.
Insofar as there was a sole purpose, then
Well, if the sole
Then
purpose
that-
is tax advantage, then that's
that is-
easy.
But that is just FIDEX.
But what she says is, 178, the taxpayer had three main purposes for holding the bonds, two being allowable and one being unallowable. Then she quotes from Lord Justice Kitchen, ending up with the debit arose from and was attributable to Project Zephyr, but for this avoidance scheme there would have been no debit at all. And in the last sentence of paragraph 79, she says even if she had found that the tax advantage was one of the main purpose and not the main purpose, the attribution issue would still be determined as wholly attributable to unallowable purpose in line with FIDEX. Now, is that her exercising her own evaluative judgment, or is she saying that that's what FIDEX tells me I ought to do?
Well, in my submission, FIDEX would be a relevant case giving relevant guidance too, and I may have made that submission to that situation where you have our commercial purpose for holding the asset, but it is very much a bare commercial purpose of owning the asset. And you do a scheme, and but for the scheme, there would be no debits. So actually it's on all fours with FIDEX. So it is in line with FIDEX. So she couldn't be faulted for seeing that as a appropriate guidance.
Yeah.
As it was in FIDEX, not following FIDEX, because that's what you're saying.
Yes, in line,
In line
with,
as-
it's on all fours with the facts in.
Right.
She sets out the test in 177 quite briefly. Says the nexus to the attribution test is referable to the debits arising from the unallowable purpose. And that's something that arises out of the judgments in FIDEX. But I think it's consistent with what BlackRock and QuickFit
Yeah.
Just to be clear, I've said I have difficulty with my learned friend's case underground too. If this court were remaking the decision, I would obviously submit that, well, it's all very hypothetical. You'd have to also remake the attribution if you were to remake the decision. And I would say that the facts would allow that same attribution, the facts as found.
Right.
But in my submission, it's completely hypothetical. I think those are my submissions, but can I just?
Yes.
Thank you very much, Lewison.
Yes, thank you, Ms Wilson. Ms Shaw, do you wish to reply?
Yes, I have 3 points, please. My first point is, it is not an answer to say that this is all a matter of fact for the FTT, that the FTT could have found that there was a commercial purpose, but it didn't, or that it was open to the FTT to conclude that there was an unallowable purpose. Those findings in our submission are answers to the wrong question. They are answers to the question, what were the purposes for the appellant, for which the appellant was selected as the acquiring entity? And if, as we submit, the FTT had asked the right question, what were the purposes for which the appellant was a party to the loan relationship, it would not have found as it did. The upshot of the FTT's approach is that the appellant's only objective in borrowing was to generate a loan relationship debit, even though it required and used that borrowing to fund a $1.1 billion commercial acquisition. We would respectfully submit that that is an absurd view of the facts of this case, and it is a conclusion predicated on a fundamental error of law. Our second point in reply is that to apply the unallowable purpose rule in the circumstances of the present case would represent a radical extension of its remit. The cases to date in which the rule has been applied are very far removed from the present circumstances.
I'm sorry to interrupt you. Just going back to your first point, you say the right question was what was the appellant's purpose in borrowing. Isn't that exactly the question that the FTT posed at paragraph 143? The specific question I asked therefore is what was the purpose for the appellant in issuing the $550 million loan notes to JTI? That is the right question, isn't it, on your submission?
I accepted that was the right question. I said, so far, so good. And then you go on to read the rest of the decision and the guiding principles, and it's quite obvious that what the FTT is doing is looking at the purposes of JGI and JTI in relation to the wider arrangements. So my second point in reply is that the application of the rule in the circumstances of the present case would represent a radical extension of the remit of the unallowable purpose rule. And I say the cases to date, the circumstances of the cases to date in which the rule has been applied are very far removed from the present circumstances. So in FIDEX and TDS, the loan relationships were used to produce tax losses where there was no economic loss, and where simply continuing to hold the assets would not have resulted in any debits at all. And even the revenue accepted, or certainly yesterday, that the circumstances of the present case are very different to those at issue in FIDEX and TDS. And in BlackRock and QuickFit, Lady Justice Falk makes a point of emphasising that the analysis, the outcome in those cases is very much dependent on the particular circumstances of those cases. And she stresses that the rule is not intended to capture arm's length borrowing for genuine commercial acquisitions. The point in BlackRock and QuickFit was that there was no operative commercial purpose for the loans. What drove the borrowing or the increased interest rate was getting the loan relationship debit. But for the tax purpose, there would have been no loan or no increased interest on the loan. In this case, what drove the plan, what drove the borrowing was the acquisition of LTT. But for the acquisition of LTT, there would have been no loan. So we say to describe the plan and the borrowing as a tax-driven scheme is the tail wagging the dog. The objective was to acquire LTT. That was what was to be achieved. The plan and the borrowing was how that objective was to be achieved. And we say the fact that the how was devised with tax efficiencies in mind is entirely in accordance with what Lord Upjohn observes in Brebner. If there are two ways of achieving a commercial objective, one of which is more tax efficient than the other, it doesn't mean that by choosing the more tax efficient route that tax avoidance is a main purpose. So if the choice of the appellant as the acquiring entity for reasons of tax efficiency falls foul of the unallowable purpose rule, then it must follow that there is no legitimate choice between equity and debt funding for reasons of tax efficiency, and nor, contrary to what Lord Upjohn says in Brebner, is a taxpayer free to choose to structure their commercial affairs in the most tax efficient manner. And then the third point I wanted to make by way of reply is that it was said yesterday that the FTT rejected Mr. Olson's evidence as to the commercial purposes for which the loan relationship was entered into. And I just want to correct that contention and start by taking you back, please, to paragraph 6 of the FTT's decision. At 5 lines down in paragraph 6, the FTT says, whilst parts of Mr. Olson's evidence are helpful in understanding the operation and business of the group, I find that the material aspects of Mr. Olson's testimony as respects the adoption of the acquisition and financing structure involving the appellant represent an account of events given with the legal issues in mind. So what the FTT was rejecting was Mr. Olson's testimony as to the adoption of the acquisition and financing structure involving the appellant. In other words, his evidence as to the reasons why the appellant was included in the acquisition structure, not evidence as to the purposes for which the appellant was a party to the loan relationship. Those reasons are then discussed under the heading at 155, what evidence of business or commercial purposes. And it is clear from the reference in 155 to paragraph 102 that the purposes referred to are the purposes for which the appellant, as opposed to any other group entity, was chosen as the acquiring entity. So if we just go back to 102, the FTT refers to Mr. Olson's evidence and oral evidence to various non-tax advantage considerations to support the use of a UK company for the LTT acquisition. So when the FTT refers to the putative non-tax advantage purposes for the appellant being party to the loan relationship, it is plainly referring to the purposes identified in paragraph 102 and then discussed in paragraphs 155 to 164, which are the purposes for choosing the appellant as the acquiring entity and not the purposes for being party to the loan relationship.
Yeah,
Those are my points in reply.
thank you very much. Well, thank you both very much for your interesting arguments. It will not surprise you to learn that we will take time to consider our decision. You will receive draft judgments in the usual way. They come subject to a fierce embargo, which means what it says. So distribution of the draft is limited. That will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the draft judgments, you will be able to agree a form of order. If you can't agree a form of order, then please make short written submissions and we will make the order that we consider to be appropriate. Hand down in due course will be done remotely by release to the National Archives and emailed to those on the distribution list. Thank you very much.
Court ready, people?